Thank you for your patience. And thank you for joining our contract webinar today for the Dance Workforce Resilience Fund. My name is Ritika Ashok. I am the grant making coordinator at Dance.NYC. I am a tan, brown-skinned Indian American woman. I have round brown eyes and long black hair that is down by my shoulders today. I am wearing a navy blue t-shirt. I have small gold hoops and a gold necklace, and I'm sitting on a black chair in front of a blurred brown background. Thank you to our accessibility providers today. ASL interpretation for this webinar is being provided by Diane L. Barkstrom and Johnny Cullen on behalf of SignNexus. And our closed captioning is being provided by the Viscardi Center. Thank you both for being here. We've just added a link in the chat. That's where you can access captions for today. To pin our ASL interpreter, you can also click on the dots in the top right corner of your video screen to pin. Please also note that this webinar is being recorded. The webinar recording, the slides, and transcript will all be made available on the Get Help page on Dance.NYC's website on the DWR Fund main page. I will now pass this over to Sarah Rower, who is Dance.NYC's Interim Executive Director, to walk us through a land acknowledgement.
Hi everyone, I'm Sarah Rohr. As Ritika said, I identify as a non-disabled, cisgender, white, queer femme. I have pale skin, short salt and pepper hair with a bleached streak through the curls over my forehead, and today I'm wearing a deep teal dress that appears like a V-neck at the top. I'm adorned with some delicate gold-colored spiral earrings and a tiny boulder opal pendant, and a large, long copper chain holding a pendant that's outside of my limited Zoom frame. Behind me is a rather generic white wall and part of a granite fireplace that are part of the conference room at the Mertz Gilmore office in Lenapehoking, also colonially referred to as the Gramercy area of New York City. I'll move us into our land acknowledgement. Dance.NYC would like to recognize our country's history and its legacy in the space we occupy. Parts of this acknowledgement have been adapted with the guidance of Indigenous dance artist and activist Emily Johnson, who worked on Dance.NYC's land acknowledgement. It is iterative, and it may undergo revisions regarding the Ramapo people in the near future as we learn from an expanding community of Indigenous artists. I'd like to acknowledge that the city of New York is on stolen land, more specifically Lenapehoking, the unceded homeland of the Lenape people, who are recognized federally in this country as the Delaware Nation of Oklahoma and Anadarko, Oklahoma, the Delaware Tribe of Indians in Bartlesville, Oklahoma, and the Stockbridge-Munsee community in Bullard, Wisconsin. In Canada, these folks are recognized as the Munsee Delaware Nation and the Moravian of the Thames First Nation, Delaware of Six Nations. We recognize that as an organization based in NYC, we have benefited from and continue to benefit from the systemic displacement and erasure of Lenape people and governance on their land. Please join me in taking a moment to recognize and reflect on the centuries of violence, displacement, forced migration, and settlement here, as well as the centuries of resilience and leadership of all Indigenous and First Nations people on Turtle Island that have led to our livelihoods in New York City today. You could begin by joining Dance.NYC in supporting Lenni Lenapex Quihok, a group of Lenape matriarchs from 5 of the federally recognized Lenape tribes who are working to increase Lenape presence in Lenape land, both immediately and in the long term. Even if you cannot donate at this time, I urge you to bookmark this site as it's both stunningly beautiful and also contains a plethora of wonderful free educational resources. There will also be links in the chat. And as we close, I would love us to just take a moment of breath and silence together to integrate and enliven this information. Thank you. And I'll move on through a few guidelines for our time together here. Pretty regular if you've been on many Zooms, which I know that we all have. Please mute yourself if you are calling in or if you are not bringing up a question in the moment. Dance.NYC currently has all participants muted. Please submit questions as they occur to you. Feel free to use the chat feature and we will answer as many as we can during the end at the Q&A portion of the webinar. When you submit questions, use the chat to everyone feature so that everyone can see the questions being generated and help to avoid duplication of those questions. All questions will be saved so that we may be able to address them later if we don't get to them now. Consider asking questions that might apply to additional potential applicants, keeping in mind that we do offer one-on-one legal assistance and direct email addresses and a direct email address available for hyper-specific questions or inquiries. We don't recommend the raise your hand feature in the format of this webinar as we're unlikely to be able to pause the presentation prior to the Q&A section and we don't want to miss the question that you may have. And with that logistical information, I will now pass it on to Jonay Williams, our DWR Fund legal consultant, who will lead us through this webinar presentation. Welcome, Jonay.
Hi, thank you so much, everyone. I really appreciate it. Just so that everyone is aware, I am a Black femme queer woman, and I have dark, long Black locks. I'm wearing a brown shirt that comes up over my neck, and I'm on a white background. Next slide, please. Okay, so we're going to go over the agenda today. Just really quickly, I'm going to start with who I am, just for those of you who aren't aware and have never met me before and maybe haven't had the chance to watch the first webinar that we did. Then I'm going to go through a quick recap of the Dance.NYC contracts. We have two, and then some techniques to negotiate the terms of the agreement, and then we'll move straight into a Q&A. The recap is going to be pretty quick because we do have an entire webinar where we go through the contract extensively. So just make sure that you check that out if you didn't get the opportunity to. And then as far as the techniques for negotiating the terms, I'm going to give you some general ways to negotiate, and then we will then utilize those to apply those to the actual contract and some of the terms within the contract, because everything isn't going to be negotiable. Next slide, please. But before we start, I just have to do a little disclaimer. This workshop is for informational purposes only. J. Williams Law PC assumes no liability for the use or interpretation of any of the information contained in this workshop. It does not establish an attorney-client relationship and should not be an alternative to obtaining legal advice from your licensed attorney based on the specific facts of your legal matter. Now let's get that hoopla out the way and get to what you really came for. Next slide, please. Okay, so a little bit about who I am. I'm an attorney and a business advisor for business owners and public figures. I started my firm in 2012, and I also have started a business coaching and advising company back in 2013. At this point, I have now coached thousands of people on the foundations of business all over the world and negotiated deals for films, docuseries, TV shows for HBO, Netflix, Amazon Prime, South by Southwest, Hulu, name it. Personally, I am a former musician and currently a playwright, and I'm also working on a novel this summer. Next slide, please. Okay. Yes, start there. So let's switch to taking a look at the contract really quickly before we go into this piece. So could you switch to the ICA and then we'll come back to this. Okay. So we might need to increase that a little bit because it's a little, yeah, there you go. Okay, perfect. Okay, so this is the current contract that I created for Dance.NYC that you can utilize for your negotiations on different jobs that you take. Just to run through it very quickly, you can scroll down. The initial part is the parties. That would be you and whichever entity is hiring you. Then we go straight into the duties, basically what your role going to be, the production, and what their idea of the responsibilities are for you. We go straight into the location of where it's going to be, whether it's going to be a remote or it's going to be on site. We can keep scrolling. Like I said, I'm just going to run through this really quickly. There's a section for a proposed schedule, the working conditions, which uh, pause right here for a second. Want to make sure that you understand that you are allotted to have the proper working conditions for you to complete your job. So we have air conditioned or heated rehearsal space, accessibility, etc. So I just want to notate that you do have that inside of your contract so that you can perform the duties of the contract on your end to the best of your capability by having proper working conditions. The term of the agreement will really depend on how long the job is that you're on. Compensation will be whatever they offer, unless that's negotiable. We can keep scrolling. And then we have the method of payment. That would be how they're going to pay you, whether it's going to be biweekly, monthly, and the method of payment that they're going to use. Expenses, which is basically the out-of-pocket expenses that you incur on the job, and if those expenses are going to be reimbursable. This section number 8 is very important. We'll pause here. Your independent contractor status. This basically says that you as a independent contractor, you are responsible for paying your own taxes. You are not entitled to benefits, vacation, sick leave, things like that. So just so that you know, as an employee, you are entitled to those things, but as an independent contractor or a freelancer, the company that hires you or the entity that hires you is not responsible for providing those things. And so it's stated here. So you are under independent contractor agreement status, which means that the terms of your job that you're working on will be governed by this contract should you choose to use it. Section 9, intellectual property, that basically talks about how you would contribute to the show. If you are contributing in any way, that you have your creative work inside of the show or inside of the job as part of the job, and how that's going to be administered, or how it's going to be controlled or owned. So if you're putting together products, design, choreography, things like that, there should be a place for negotiating those items within the job, because if they want to take your work and then incorporate it into a production, you do have rights around your contributions. Keep scrolling. We have your name and likeness, which is basically your name and likeness being used inside of the production. So let's just say you have a playbill, your name and likeness is going to be on that playbill. What we have in this contract is that your name and likeness can be used in connection with the job that you're on. So they can't take your name and likeness and use it on any other production that you are not a part of. When it comes to section 11, which is non-disparagement, this basically states that they're not allowed to disparage you, nor are you allowed to disparage them in the event that you terminate this contract or that you decide that you do not want to work with them anymore. Everybody keeps their composure around the way it is that they're going to conduct themselves outside of this agreement. That protects you so that you do not get in a position where they can badmouth you to other potential jobs and employers. And it doesn't put a muzzle on you in that you can speak about what's factual about your experience. So you can do that publicly or privately, but just making blanket opinion statements like, they suck, that kind of opinion, we put down as non-disparagement, and that goes both ways. Indemnification, that's number 12. Indemnification basically is a very important clause that says that if they end up getting sued for any reason, like the production or the company, that they will then indemnify, aka protect you, by saying that you had nothing to do with it, nor can you be brought into the lawsuit as an independent contractor. So if there is a lawsuit that comes against that company or that entity, you are not going to be a part of that lawsuit. That protects you and your personal assets. This is a very important clause. Make sure that it's in every single contract that you sign from here on out, even if it's not this one, even if it's for some completely other type of contract. Make sure that the company that you're contracting with indemnifies you. We can scroll down. The resolutions of disputes are basically the court, wherever you are going to be administering this contract. So let's just say if you're in New Jersey, then when you give them this contract, New Jersey will preside over this contract. If you're in New York, same thing. Force majeure is basically speaking about if there's an issue. So for example, if we had, an act of terrorism or interruption with transportation. In New York City, we use a lot of trains. Or if there's an issue like a pandemic that happens or something along those lines, that both parties will be relieved of their duties until that event clears. So that's what that means. Let's go to termination just really quickly. Termination is basically either party can terminate the agreement, and you can be paid a prorated per day hourly rate through the date of termination, depending on if you place it here in this section. Choice of law, we went over that. Severability basically means that this contract cannot be completely thrown out. I'm using layman's terms, simply because there might be a clause or a portion of the contract that you and the other party that's hiring you may have an issue with. Let's just say there's a section that you're fighting over in court. That doesn't mean the entire contract is invalid. Let's keep going. Assignment. Assignment basically means that you cannot decide to unilaterally assign your rights in this contract to somebody else. So let's just say you have a friend who can step in your place. You get injured and you say, oh, my friend can step into the production. This contract limits that, and it also limits their ability to then take you and say, hey, we're going to put you on a different project instead of the one that you auditioned for. Notices is basically if you do have to file a lawsuit or they have to file one against you, the notices will, the notice that you are being served can come through the purposes in this part of the contract, which basically is certified mail, return receipt, email. It should be in writing. Let's keep scrolling because we're almost at the end here. The modification of this agreement has to be signed by both parties. So if you both decide to change anything within this agreement, you both have to sign it. So we're gonna come off of this this contract for a moment and go back to negotiating. Thank you for that. I appreciate you scrolling. I know that it was a mouthful. So when we're talking about negotiating techniques, when it comes to this contract, you want to start with a casual introduction of the contract, which basically, oh, thank you for letting me know that. Sorry, I did not realize that I was off. So you want to start with a casual introduction of the contract, which basically means you're not going to present it in a super formalized manner, like, okay, I'm going to send you my contract now. Da, 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 da. You're not going to do it like that. You want to just say, okay, great. This sounds like a great job. I'm really excited. I'm going to send over my agreement so that we can go over the terms, something more of a softer kind of intro, because of the fact that this contract, or the way it is that Dance.NYC is empowering you to shift how you work within these companies and how you get hired, and that is not necessarily an industry standard, we have to introduce it in a softer way from a negotiating standpoint. Now, when it comes to the terms, you need to know what is most important to you before you negotiate. So let's just say if pay is the most important piece for you, or the working conditions, for example, you need to make sure that you have those points written down and what you would like in those points. So if you want your pay to be increased, if that is an area for negotiation, because sometimes it's not, or you need a certain type of working condition that maybe wasn't included in the contract initially, you need to make sure that you have those points written down and arm yourself with research, meaning, is what you're asking for something that is industry standard? Is what you're asking for something that's outside of the norm? Also, a question would be, what have they, the company or the entity that's hiring you, what have they offered dancers before? So let's just say the pay is lower than what they've offered in the past, or the working conditions are different than what they've offered in the past. You need to know that. So arm yourself with the research of understanding what they have offered and what they have done in the past, and then also arm yourself with what's actually normal and standard in the industry, if anything. It may not be, whichever, depending on which term you're deciding to negotiate. Then know the line that you're unwilling to cross and which terms, if not met, you're willing to walk away from. So for example, easiest one would be pay. If you have a certain threshold that you will not fall below as it relates to pay, then you need to know that going into the negotiation that you are going to walk away if you end up with a pay that is XYZ lower than what you intended. That's very, very important, because if you go into the negotiation without knowing your boundary and your line, then what will end up happening is they might be able to convince you in the moment when you get a little flustered or you get a little worked up. You may end up folding or shifting what you want or acquiescing to their pressure because you're not prepared. So it's very important to know what are your lines that you're unwilling to cross when it comes to this. Then you need to communicate your value add. So that means write it down prior to you coming into the negotiation. So an example would be, do you have a really great track record of working with different productions and your reputation precedes you? Do you have social media value? You can bring in more ticket sales, for example, or you have an online presence that would be beneficial to them. You want to look into what is important to the other company. It's not just what you want, it's what's you can read and see and know that's important to them. So there's lots of ways to observe that. So you can look at previous shows that they've done. Maybe they're doing the next most successful run. Maybe they are in a smaller venue and they need more ticket sales. Maybe their priority is getting the best performers for the lowest price. You need to understand before you walk into the negotiation what's important to them and what you actually can offer that's in alignment with what they're looking for. Okay. Next is we have what you call a counter offer dance. So let's just say you go into the negotiation and you're looking to negotiate certain terms that are important to you, like the working conditions, pay, etc. Once you know what you're looking for and you present what you want to change in the agreement, that is when you just hang out. Do not go back into negotiation trying to communicate your value or push, the narrative or change what you're asking for. Don't do any of that. Once you put it out there, they need to understand that you are firm in your position. So you present the points that you want to change, or the things that you want to add within the agreement. You pause, you let them come back to you with their counter offer if they decide to bring forward one. If they don't, and they dismiss you and say, you know what, too much for me, thank you very much, then your next step will be either you will fold completely and just go straight into what it is that they want, which I don't recommend. You walk away, or you come back with a second counter offer, which is basically, okay, well, what portions of the contract or what request I have that don't work for you. I'm willing to take the job. I'm just curious if there's any room for negotiating on these points. So those are the three options when you're doing this particular technique. Does that make sense? I hope it does. So um there's particular parts of this contract.
If you update your lock screen settings, next time I can help with this when your screen is locked.
Wait, what's happening? Was that a recording? I'm sorry, I don't see what's happening. Okay, got it. So where was I? Oh, so we're going to go back to the contract, or actually look at the certain points that can be negotiated in the contract. So can you go to the next slide, please? Okay, so the areas of negotiating within this contract, the one that I have provided for you. So these are the main areas where you're going to negotiate. I do not recommend that you negotiate areas like indemnification or severability or these other, more technical areas. These are the parts that are really the most important to you as a performer, as a dancer, as someone who's presenting the contract as an independent contractor. So we have pay, the method of payment. These are two things that can be negotiated sometimes, not all the time. They may have a standard way of handling pay and method of payment, but if that's important to you and it's something that may be negotiated, I would try. Working conditions, we spoke about that. Expense reimbursement. So some productions may reimburse for expenses, some may not. You can, and this is a place where there's probably some room for negotiating, especially if the pay section is lower. So if they're paying you lower and then they're also not paying for expenses, that might be something that you can negotiate. Can you at least pay for my travel? Can you pay for my my travel to and from the venue, or my costume, or whatever you need to carry out the performance? You can ask for that in the expense reimbursement. The other area is intellectual property. This can be complicated depending on what you have contributed or what you plan to contribute, or what you may have freelanced within a production. So if you are contributing substantive pieces of intellectual property, meaning design, choreography, things like that, you can speak to the production company. And let's just say if you present them with this contract and you need to renegotiate that point, then what you would put in the contract is what they call an appendix or a modification. And again, that would need to be signed by both parties, right? So the intellectual property piece really depends on what you're contributing, and you may not be contributing anything. You might just be going into the job, doing the production as is, and then you continue to move forward. But if you are contributing something substantive to the production, that may end up staying in the production beyond you. Like, let's just say you leave and they're still utilizing your work. That's something that you should be negotiating to make sure that you either own that piece of intellectual property or they're licensing it from you and paying you a licensing fee to utilize that piece of the work that you contributed to that production. So those are the areas where I would recommend you may have room to negotiate. We have a smaller contract that is the email version of this, and it has specifically these areas inside of that contract as well. And this can also happen prior to you presenting the contract to them. You can negotiate these points before you insert them into the contract and present it to them so that it's done preemptively versus after you present the contract and then you have to go back and negotiate later. So those are the areas there. Can we go to the next slide? I think we already took a look at the contract. So, okay, we can skip that. So, okay. So now we come to the section where we're going to do a final Q&A. But before we do that, I want to speak to you a little bit about what will happen when the negotiating party, the other party, the individuals who are hiring you, when they may come and push back. So they may use certain intimidation tactics to push back at you when you present your offer or your modifications that you would like included into the contract. So one of the things that they may do is play on the fact that they're a big production, they're bigger than you, you're just a lowly, dime a dozen dancer, those kinds of setups. You, in that instance, you would play up your value. So you would talk specifically about the value that you offer in your reputation, your following, for example, or, whatever you've contributed from an IP standpoint, whatever you have as value adds, you would communicate that as the counter to them trying to diminish your value to make you acquiesce to what they want. Another one is you might find this often in lots of scenarios where they may go, "Oh, my hands are tied. I can't do anything about it. I'm sorry. We're already doing things this way." You find this a lot in nonprofits, by the way. "Oh, we can't do anything. Sorry." That's fine. What you will say in that instance is, "Oh, that's really a shame. I was interested in working on this project." And then you might present a counter offer and say, "Okay, maybe it's just these 4 points versus these 7 that I originally presented to you. So, okay, is it possible? Can we present it? Can we, utilize these 4 points? Can we negotiate here?" This just happened with a friend of mine. I actually just quick little side story. I just negotiated for my friend to get 50% back off of her hotel room because of the fact that there was an issue with her room. And I spoke to the manager and I said, "Listen, this is unacceptable." And he was like, "Oh, my hands are tied. I can't do anything. It's on, I'm sorry." I was like, this room is not acceptable for her. And so what is it that you can do? Versus him just saying, "Oh, my hands are tied. I can't give you a refund." I said, "Well, what can you do?" He came in and he said, "I can give you 30%. I said, "That sounds great. However, 50% would be better because she's staying in this room and she doesn't have these XYZ things." So again, I presented a counter offer. He accepted the counter offer. He said, "Yes, we'll do that and we'll move her to another room." I said, "Okay, that's fine." I called her to make sure that was okay with her. She said, okay. She got 50% off the room and she got moved to a better room. It's literally just a dance, counter offer dance. Next thing that they may try to do is they may try to play into the fact that you may need the money. That is a typical negotiating thing. Like, "Oh, we understand you, your hands are tied. You really need the money, XYZ. How I respond, or how I recommend you respond, is silence. Don't play into that, because your insecurity or your anxiousness might come up around your financial situation and it will make you fold. So if they say that, say, um, don't even address that, but go back into the negotiating points. Like, yes, I understand that. However, these are the things that I'm looking for. So those are just some of the tactics that you can use to circumvent the pressure that you may experience from actually having to be in the negotiating process. And so now we can go to the Q&A. And if you have any questions, please let me know, and I'm happy to answer them.
Hi, Jonay. Thank you so much for all this amazing information.
Um,
I want to really appreciate that you used a dance metaphor talking about the dance of negotiating back and forth. So,
I didn't even pick up on that. That's so funny, but yes, that's
yeah.
exactly what it is.
Love it. I just want to introduce myself quickly, everybody. Hi, I'm Anne-Marie Lonsdale, Interim Grantmaking Manager with Dance.NYC. I am a white woman with brown hair and a ponytail, sweaty face, wearing a black shirt with a collar, sitting in front of a teal wall with some artworks upon it. We're going to move into the Q&A portion with Jonay now. Please submit your questions to the group using the chat feature on Zoom. Please consider asking questions that may apply to additional potential applicants. And also keep in mind that we have one-on-one legal assistance and direct email advice via our DWR Fund email address for hyper-specific questions or anything that you might not feel comfortable sharing. And we also have a few questions from our Instagram polls, so we will be able to access those as well. I see one here already. Jonay, can you give other examples of value adds besides reputation and social media following that you could use when negotiating? Great question.
You can use successful work history. So it might not be your previous reputation, meaning like your name has carried you, but you can talk about the kind of the ways in which you have shown up in previous work experiences and what you added to those productions as well. You can speak about your IP. Like, that's something that we talked about. Speak about the ways that you have added value to other performances from an intellectual property standpoint. You can also talk about your ability to maybe even work with the sales of the production, meaning like help the sales move forward with the production if that's what they're looking for. The most important thing that you need to think of when you think about value adds, number one, looking at yourself, asking yourself the question of, what are the ways that I'm a value add to any place that I go? You know, I come in, I have a great attitude, I come on time, I have a great work ethic, et cetera, et cetera. The other thing is looking specifically at what they are looking for. So if they're looking for, like, let's just say they're looking for your certain demographic, and there isn't, you know, a lot of people in that area that fit that demographic, you can utilize that as a leverage. You know, there's so many different ways that you can utilize the various different intersections of your identity, and how that contributes to the overall the character or the performer that you are, you know, presenting as, how that adds value. They may not have seen that. It's just like with The Little Mermaid, for example, or like other shows where it's like they're used to having a certain demographic and you add something different. You're really looking at, what does the production want? What are the things that they are looking for? And then how do you fit within the schematic of what they're looking for, in addition to what you carry yourself as an individual performer.
Thank you so much, Renee.
Oh, one other thing, it might also be skills too. That's another thing. So let's just say you have a particular dance skill that other people don't have, or a particular way that you perform that might be different. You might know how to tightrope, or I don't know, but it might be a skill that you have that maybe is unique, that isn't something that other people have. So that's another thing. Sorry, I didn't mean to interrupt you, Anne.
No, no, no. You're answering the question fully and beautifully. Thank you so much. That is a great point. So, and a thank you from Isabella as well. Next question, really on people's minds lately. Do you know of any avenues through which people are gaining intellectual property rights against AI co-option or use of AI potentially? I think this could mean anything from AI using a dancer's body to like create images, or any kind of large language model co-option of intellectual property offered by a dancer.
So when you say, do I know any avenues, that's the part that I'm a little confused by. What do you mean, do I know any avenues?
Then feel free to chime in the chat if you have a specific question, but generally speaking, I would wonder if this had to do with writing AI protections into contracts, or any kind of ability that a dancer might have to assert their rights to ask a choreographer or a company to not deploy AI or use their intellectual property to feed an AI.
So when it comes to intellectual property in general, the law is not moving as fast as AI, obviously, right? So it's not doing that. However, intellectual property law is pretty vast when it comes to the types of IP that can actually be protected. What you can assert in your contract is to ensure that any aspect of the intellectual property that you contribute cannot be, and underneath the law, it says this cannot be replicated, reproduced, utilized in any way, creating any derivative works, that would be AI, any derivative works from your intellectual property without your express permission. So you can have that within your contract. And that will kind of help assert that. Right now, I know that there's quite a bit of talk around AI and what it can and cannot do, and the law hasn't fully wrapped around that, but you are protected from an IP standpoint, and you can utilize that to say, hey, my IP cannot be reproduced, no derivative works created from it, et cetera, et cetera. And those are all of the rights that you have that you can assert that are actually federally protected rights under intellectual property law, at least in the United States. So I'm sorry that it's not going far enough yet, but I do think that the law is going to catch up with AI once they kind of understand the impact and implications. But until then, you can put it inside of your contract.
Great, thank you so much. And that for the group would apply to likeness, to intellectual property contributions, to the choreography itself, and to the expression of the dance, which is the dancing.
Correct.
Cool.
And name and likeness, because I do see that question here. You mentioned likeness earlier. Can you help clarify? Sure. So when we're talking about your name, it's your actual specific name. Your likeness is like your image, like your, specific image, face. Like, this is my likeness. If you took a screenshot of me, this is my likeness. My name is right there, Jonay Williams. So those are the two aspects. So when they're using your name and likeness, like on a playbill, for example, they're utilizing, your actual image, your actual face and body to put on a particular piece of marketing to promote your position within that production. So it's a legal term, name and likeness, but it really just means your person and your name specifically. They can't take your name and then put it on another person and then say that they're you. Does that make sense? I hope that makes sense.
Yeah, that totally makes sense. Thank you. All right, one from the gram, because I'm not 43, I'm hip and awesome. How do I know what the reasonable rate of payment to negotiate for? You mentioned doing research. Are there any resources you would recommend starting with?
Started with Dance.NYC. That's one. And looking at off the top of my head, I know that there are New York resources to look at like freelance pay. I know there's like the Freelancers and Free Act. They might have some resources there. But really, you would just have to go through either dance related organizations to see what the livable wages are, et cetera. You might have to do the research of asking other performers that were in the production or previously in the production. You might have to do your Googles. Those are just some ways that you can do it, but I would start with dance organizations, then kind of branch out from there. And that's the way that you would kind of look into it. It's not always, and I know that's not a completely satisfying answer because it's not always a clear-cut thing. Sometimes they don't post what they're paying. Most of the time they don't. So you really just, your research around it is like looking at what's the industry standard for the kind of position that you are taking. What is the rate that they've previously paid other people? What is the livable wage standard that is asserted in NYC, for example? What are the dance organizations recommending around this particular type of performance if you've never done this type of performance before? So there are ways that you can look into it. It's not a clear science, but those are the ways that you can just start looking into it.
That's amazing. Sarah, just wondering if you want to comment on the pay standards that you're describing, but I just want to also offer, Janae, you mentioned Freelance Isn't Free. That is an amazing resource that exists at the Freelancers Union, and that's now New York City law. And there are lots of really good resources that are available online for freelancers, both around rates and contracts, but also around recourse for if a payment doesn't come through. And that actually touches on our next question, also from the Instagram. If someone ghosts you before paying, how can you get your money for services rendered?
Okay. So when it comes to someone ghosting you, the most important thing that you need to have is your receipts. So if you have a signed contract or an agreement, even a text message, if you have something that states that they were going to pay you and you have proof that they have not paid you yet, that is something that you can bring to court. And also you can go to the Freelance Isn't Free Act website, and they do have a whole setup for you submitting that issue. So if they ghost you, there is recourse underneath the law in New York City around that. But also, if that is not possible, you can take them to small claims court. I know that it's a pain, but it's not super expensive. And it might be worth it if it's a bigger job to do it that way. The other thing is that I don't always recommend this, but you may have to blast them. I had a client of mine who did not get paid, who was ghosted, and she had to blast them on social media. They promptly responded. And and she did not have a large following. She wasn't like some, super big creator. She maybe had like 1,000, 2,000 followers. But the fact that you were willing to go public with the fact that they ghosted you and wasn't paid, that was another way to kind of force their hand, or at least their response. The other way is a demand letter. So you can issue out a specific demand letter that states what they were supposed to pay you, referencing the contract, the text messages, the emails, or whatever, and then demand that payment within a certain amount of time, or you're going to take it to court. So those are a few ways that you can kind of force their hand in a sense if you have that issue. So to recap, freelance isn't free. Utilize your demand letter, social media blast, any of those kinds of things. Listen, whatever works, because sometimes people they need to be, blasted sometimes, when they don't move forward. And that happens often when it's a smaller contract, when it's not a large amount. When it's a larger amount, there's more for them to lose. When it's a smaller amount, there's less for them to risk. So you may have more instances of ghosting in that regard. So those are the resources.
Beautiful. Thank you so much. All right, I think we're going to start to wrap up. Jonee, thank you so much for all this amazing information today.
Yes, my pleasure.
So good to see you as always. And I want to thank everyone for tuning in to Dance.NYC's webinar on the DWR Fund. Any resources shared today will be posted on the program's webpage on Dance.NYC. Our landing page is currently in the chat. And as a reminder, you can schedule a one-on-one legal consultation session with Jonee through the link available now in the chat, and it's also linked on the DWR Fund site. If you have follow-up questions or comments, please email us at dwrfund@dance.nyc. And we want to thank again our ASL interpreters from Sign Nexus and our captioning providers from the Viscardi Center. So wishing everyone a beautiful day, stay cool, drink some water, and we'll see you soon.
Bye, everybody.
Thank you.